arguments during Gray's sentencing hearing. The ruling came about an hour after the court went to recess following the closing statements. Let's listen in to this sentencing.
14 years of age. Those who appear regularly in front of me have often heard me lament about the difficulty in sending a young person to prison. And here, as everyone understands, the minimum sentence is life with parole. Now, the appellate courts have said that children are constitutionally different from adults for purposes of sentencing. That stems from an understanding that juveniles aren't fully formed cognitively. Hallmark features of a juvenile include immaturity, impulsivity, recklessness, and a failure to appreciate risk and consequences. Because of these factors, the Supreme Court says that the Eighth Amendment prohibits the death penalty for juveniles. The Supreme Court also disfavors life without parole for juveniles, declaring it to be a constitutionally forbidden, disproportionate sentence in all but the rarest of cases. Life without parole is thus authorized only for youthful crimes reflecting permanent incorrigibility. Life without parole is barred for crimes that are born out of a transient immaturity of youth. So I recognize that with your guilty plea, you've assumed responsibility for your crimes. You have made a lengthy and public trial unnecessary. I also recognize that you were failed by each of your parents. You were failed by your extended family. To a certain extent, you've been failed by a society that can't stop propagating this misguided value in online cultures and social media, rather than making genuine interpersonal connections and relationships. But that failure does not absolve you from who you chose to idolize, worship, and become. 4 lives were stolen. 2 of them really just beginning, and it wasn't done out of fear or anger. You weren't being bullied at Apalachee. It wasn't done out of hatred. You didn't even know anyone at that school. It was done for the infamy of it. Now, your childhood instability and neglect would explain or mitigate finding yourself in one of those problematic places that Dr. Richards testified about. But planning, fantasizing about, visualizing, and executing a school shooting don't put you in a problematic place. It puts you in an unredeemable moral wasteland. Your crimes do reflect permanent incorrigibility, and I will sentence you to life without parole for each of the malice murders that you committed. You understood the horror of what you were going to do. You studied the trials of those other shooters. You even critiqued the victim statements given in those cases, and yet you did this anyway. You wrote, "I want to make history. I want people to remember the pain I caused." And there you succeeded. The pain that you visited upon this community is unlikely to disappear in my lifetime. You do not seem to be tormented by what you did. You seem to relish following in the footsteps of the murderers you idolize. You aren't racked with guilt. You're proud of yourself. Less than a month after the tragedy, you weren't concerned with the horror you wrought, but rather with finding out which mass murderers they were comparing you to. A youth may fail to consider the harm his rash actions inflict before acting, but you did consider it. You studied that pain when you researched the trials of your profane idols. You contemplated that pain over and over. This wasn't transient immaturity. It was deliberate, contemplated evil. You were all too aware of the court outcome of those mass shootings because you studied and obsessed over them. You know that the Aurora Theater shooter received life without parole. Nicholas Cruz received life without parole. Ethan Crumley, a juvenile, received life without parole. Yet you were not dissuaded. Your plan was not hastily hatched. It was a slow boil simmering more than a year's time. You savored the thought of it, you visualized it, and you fantasized about it. You broke it down step by step in visualizing what you were going to do. The thought of mimicking these other mass murders is what brought you joy. Now, for the rest of us, there is no joy here today. There's only a measure of closure. The slain will not return to life, the injured will not forget their wounds, and a 16-year-old boy will live and die in prison. You have certain post-plea appellate rights I need to inform you of. You have a right to file a notice for a discretionary appeal within 30 days of today's date. You can have a lawyer represent you for that, but you are not entitled to court-appointed counsel. You have a right to file a motion to withdraw this guilty plea because it's less than 30 days before the term of court ends. You have to file that within 30 days of today's date. That would be to correct a manifest injustice. You do have a right to a court-appointed attorney for that post-plea appellate right. If you need a court-appointed attorney, you need to promptly apply for one so that one can be appointed to meet that 30-day deadline. You also have a right to file a petition for habeas corpus to challenge any legal errors in the proceeding, any violations of your constitutional rights. That is a civil proceeding for which you do not have the right to court-appointed counsel. Each of the malice murders will be life without parole, concurrent to one another. The felony murders and the related aggravated assaults for those all merge as a matter of law. Each of the aggravated batteries will be 20 years to be served in confinement consecutive to the life without parole. The aggravated assaults and the cruelty to children that do not otherwise legally merge will be 20 years concurrent to the life without parole. Is there anything else I need to address?
20 years on the aggravated battery, second, are they currently each other?
Yes. All right. We're adjourned.
Judge Prim handing down the sentence there, life without parole for the Apalachee High School shooter, Colt Gray. Just a little bit.
Thank you all for your professionalism.
No, we're not getting on you.
Okay. That was heartfelt.
Mrs. Smith, could you address some of the things that we heard today, particularly the audio tape between he and his mother? I think by most people's definition would be troubling. Could you speak to that relationship and how we got to this day?
No, that's the relationship I do not understand at all. That was the strangest thing I'd ever seen. I had heard, the way this case shook out was very quickly we realized that the shooter had been apprehended. He had given a confession. It was on tape. And then within a few days of the shooting, the investigation naturally turned towards the father when information about his culpability came in. So as we went through it, it became pretty apparent early on that the father's case would probably get to trial before the son. So we shifted and focused on the father for about a year. And then after the father's trial ended in March, we shifted towards the son. And that's when we really started noticing these things. I had heard that they'd had disturbing calls, but I haven't really listened to them. It's only been within the last 3 months that I've sat down and listened to those jail calls. And it's one thing for someone to tell you they've been talking about inappropriate things. It's another thing to actually hear the chilling words and the tone and the joy that they seem to be getting out of it. So no, sir, I could not ever understand what was going on there.
Mr. Smith, can you tell us if you're exploring prosecuting others involved in this case? I'm thinking specifically about Colt's mother and maybe some of this online community.
Well, if you look at our indictment of the father and our charging of him and why he was charged and what theory of the law we went under, it was a threefold, basically, that he was the custodial parent of the child. He had knowledge that the child had this danger about him, and he provided the firearm for the child. And because of that, we were able to prove that he was the proximate cause or a proximate cause of what happened at Apalachee. The mother does not fit that bill as far as she did not have custody. In the 2 years leading up to the shooting, she actually was only around the child physically about 3 months in the 2 years total. And she did not have custody of him. It was actually removed from her. And she was actually barred from being in Barrow County. So she wasn't even supposed to be up here. And she did not provide him with the firearm. She took some steps, not many, but some steps to actually have the firearms removed or ask the father to do that. So we don't believe we have the ability under the proximate cause of Georgia to charge her with what happened at Apalachee. The other crimes that she may or may not be guilty of would be probably outside of our jurisdiction here in Barrow County, or would entail Colt Gray being the victim. And I don't know that I have the stomach for a trial where Colt Gray is the victim.
She said it became clear that Colt Gray's trial becoming earlier before his son. Who ultimately makes that decision? I thought usually that's up to prosecution. How did that decision come about?
No, ma'am.
Father.
No, ma'am. The prosecution doesn't get to pick when trials go. It was a natural flow of things. Both of them were in custody. Whenever someone's in custody, the court will try and push that one to the front because they're in custody awaiting a trial. So both of them were in custody. We could tell that early on that Colt's attorney was looking at the psychological angle and was trying to get a psychiatrist or a psychologist to look at him and do an evaluation of him. And it was taking time. So every time the court would check in on the attorneys as to what's the status, what are things going, the state was always, we're ready. Collins' attorneys were always, we're ready. And Colt's attorneys were always, we're waiting on this, we're waiting on that. So it just became apparent to us. It wasn't anything official, but it became apparent. We could tell that it was going to inevitably end that way, that we would do.
Would you be ready for any possible appeal part of the father? That confession, taped confession, was never able to be played during his trial. Would you, if you were to appeal, would that be something you're on to?
No, the theory of guilt for Colin Gray was what he knew of the threat Colt posed. So everything we presented at his trial was his knowledge of the danger that Colt posed. The stuff that came here was not introduced at his trial because we could never show that he knew these things. So it was not part of his theory of guilt. But the jury found that based on what he did know and what we could prove he knew, that was sufficient, that he should have taken that gun away.
What's the message? I saw you talking to the family member. What's the message that you share with them?
I can't say anything to the family members. This is not a happy day. This is a relief day, I would say. But like I said in my closing, the depths of their loss I can never comprehend. We just hope that we've done honor to them. We've done honor to their loved ones in the work that we put forward, and that's all we could do.
Describe what you want Colt to take away from this, and kind of what you said in the closing argument.
What do I want Colt to take away from this? I have not going to think one more minute about Colt Gray. What I would like society to take away from this, and this was something that I didn't know existed, was this true crime community that's out there and the insidiousness of it. Whenever there's a mass shooting, I've noticed people are always wondering, well, did they vote for Trump or did they vote for Harris? Do they believe in this or do they believe in that? And that's us adults thinking, why would someone do this? But what I realized was with this true crime community, they don't have an ideology. They're not progressive. They're not conservative. They're just nihilistic. And they want to just cause harm and pain. And they revel in that. And so I want everyone to realize this is not harmless. The things they're doing online are not harmless. And we need to pay attention to when these kids start doodling these things on their notebooks and put them on their backpacks and doing these things and putting pictures on their wall. Who is that person you just put on your wall? Why are they on your wall? And if you do see your child acting this way or doing these things, please, please, please make sure they do not have access to firearms. Because like Colt, it's not going to be something where, oh, they did this little violent thing. It's going to go from no violence to mass murder. And you can't wait at that
Is there
point.
anything that can be done legislatively when you look at these chat rooms, this TCC?
I hope so. I hope smarter minds get into that sort of thing and come up with something like that. We talked a lot, and we talked with Peter Smith was the expert that we called on the TCC, and we talked a lot about, well, won't this just encourage it? Aren't we giving more ammunition to this? And we were worried about that. But we kind of fell on the side that this needs to be out there. People need to know. Because the only way you're going to stop these, you're never going to stop these kids from doing it. The only way you're going to stop this is what they call leakage, where other people see the signs and other people intervene. So
This courtroom moment will be remembered not because of the sentence alone, but because of the reasoning behind it. The judge didn't ignore the defendant's age. In fact, he spent several minutes explaining that the law recognizes children are different from adults. Juveniles are often impulsive, immature, and still developing. That's why life without parole is supposed to be reserved for only the rarest cases. But this, the court concluded, was one of those rare cases. From the judge's perspective, this wasn't a split-second decision or a tragedy born from teenage recklessness. The evidence pointed to months of planning, studying previous mass shootings, and deliberately pursuing notoriety. In the court's view, that level of preparation crossed the line from youthful immaturity into calculated criminal intent. What also stood out was the balance in the judge's words. He acknowledged that the defendant had been failed by adults, by family, and by circumstances. Yet he made it equally clear that those failures did not erase personal responsibility for the choices that followed. Legally, this sentencing reflects one of the hardest principles in criminal justice. Compassion for a difficult upbringing cannot outweigh accountability for deliberate acts of violence. The court wasn't deciding whether the defendant had suffered. It was deciding whether the law allowed any realistic possibility of release after crimes of this magnitude. Whether people agree with the outcome or not, this hearing highlights the enormous responsibility judges carry.